Nikhil, now you at the outset you mentioned the broad contours of how citizenship is important in the estate planning. Now let's take the specific cases. There is somebody who is living in US, let's say US citizen. He comes back to India and he wants to renounce the US citizenship and take Indian citizenship all over again. How does that impact the estate planning? Can you give a brief about how where all it can impact, the pros and cons of it?
Absolutely. It's a very, very good question. In fact, in the last couple of years, we have had a good number of inquiries on these lines saying, should I renounce my US status? And because US levies, taxes, even if you're not unlike other jurisdictions, saying if you're an Indian citizen, you are not a Indian taxpayer if you're not a resident in India. But unfortunately for US, if you're a US green card or a US citizenship, if you hold US citizenship, even if you're not in the US, you still continue to be a US tax resident for all tax purposes, which would mean that no matter which part of the globe you are, you still pay taxes in the US and you continue to pay tax in other jurisdictions, but of course you get credit. So therefore, this is a very, very, important question that all families have, especially the ones who are looking to come back to India, right? In that case, should one give away their US status? It's a matter of multiple factors. It's not a straightforward yes or no answer, right? What is the benefit on the face of it is that if you give up your US citizenship, of course, thereafter, you are not subject to US taxes. When I say US taxes, you're talking about estate duty or inheritance tax, whatever you want to put those nomenclature. Those aspects go away with respect to non-US domiciled assets. For instance, if you have assets in the US, you also have assets in India. If your asset component is very low in the US, but most of your assets are in India, if you continue to be a US citizen, on your demise, these assets, even in India, is exposed towards US estate duty. But if you were to renounce your citizenship, then only the US cited assets will be subject to taxes, estate duty in the US. Of course, the threshold limits needs to also be breached for that to apply. But India assets or any other non-US citus assets will not be subject to US estate duty. But is it so straightforward? The answer is no. For you to also renounce US citizenship, there are certain implications. Something called as exit tax comes into the picture. Now, if your asset values, or if you are, being a long-term resident of US and you've been paying taxes to certain levels, I think the numbers go beyond $180,000 or so. If you're paying such quantum of taxes, or if you have assets beyond $2 million, then you are deemed to be a qualified person for exit. Now, what does exit means is that when you renounce citizenship, US IRS will look at your asset base to say, oh, you bought these assets at 100. Today, the value of the assets is, say, 150. On the 50, you pay a deemed capital gains. Because you're exiting the US status, I can't further tax you on these assets. And therefore, why don't you pay up tax on notional basis today? And thereafter, tomorrow, when you're not a US person, we don't need to worry about any future appreciation which has happened. Essentially to say that this appreciation happened as a US person and therefore pay the taxes before you can leave the country. Right? That is, which is relevant. Of course, it's a capital gains tax that you end up paying. The important point here is that it's not about paying the taxes. You're paying on notional gains, which would mean that if you were to look at from a double taxation perspective in India's standpoint, you may not be even subject to tax here because it's not a sale. You still own the assets. You're not transfer these assets. The notional aspect is more from a US perspective. And tomorrow, when you sell the assets in India, you look at the previous value of how you procured these assets. And when you sell, you will end up paying tax on the entire gain. But this particular notional gain or tax that you paid or exit tax that you paid may not be even available as a credit in India. It becomes a challenge. So therefore, there is a planning that is needed to say, how do you maximize this? Can we look at actual sale happening in the US itself before you transfer? And the best case scenario to have as an exit solution is that if you have more and more liquid asset, when I say liquid asset, bank balances, etc., which doesn't have appreciation, right? Shares have a notional value which you can look at. Bank US dollars 2 million means 2 million. You can't give a different value to it. If you have asset in those lines when you're at the time of exit, you don't end up paying even exit taxes at all. That's a pro tip if I were to put out there. So ideally, that planning is very important before you start. It can't be a one-day affair. It is at least 6 months to a year of planning to say how to plan for exit and then make those specific moves about transfer. Having said that, it's not straightforward also. Once you're in India, you should also, you can't be without a passport, without a citizenship. You should also start applying for your Indian passport, or could be any other jurisdictional passport. You can plan for it. If you're looking at India specifically, the point is that you have to renounce US citizenship before you can get Indian passport, because India doesn't accept or find it legal to have dual citizenship, but US accepts dual citizenship. Therefore, if you're looking at another jurisdiction, then probably you could have the second passport and then renounce this. But if you're looking specifically for India, you have to renounce US first and then acquire Indian citizenship. Having said that, are you fully out of estate duty exposure once you move to India? The answer is currently yes. India did have an estate duty laws in the past. It has been abolished in 85. But if it gets reintroduced in India, probably planning around that also need to be undertaken. That's a future call to be taken. But today, you will be out of estate duties.